When someone passes away in Florida, the default process to transfer their assets is formal probate. It is a slow-moving system that often locks up inheritances for 6 to 12 months while requiring significant legal paperwork. There is an alternative called summary administration. This is a shorter legal process designed for smaller, simpler estates. The financial difference is substantial. Hiring a probate attorney typically costs between $2,000 and $4,500. Navigating the summary route on your own requires court fees ranging from $300 to $600. This gap means families typically save about $3,000 in legal fees. However, because this is a court proceeding, it is necessary to determine if doing this yourself is a sound financial choice or a liability. To qualify, probate assets must be under $75,000 or the person deceased over 2 years. Also, the will cannot require formal administration, and all debts must be paid or creditors must agree. Meeting these criteria is only the first step. To decide if the DIY route is safe for your situation, you have to weigh the administrative workload and the legal risks against the savings. The first hurdle is the math. You must perform a specific calculation to prove the estate stays under that $75,000 limit. This calculation includes bank accounts, vehicles, and real estate titled only in the decedent's name. Florida law excludes several categories of property from this total. Joint bank accounts, life insurance with named beneficiaries, and the primary home, or homestead property, are not counted toward the cap. This chart shows the primary trade-off. You can exclude non-probate assets to stay under the limit, but if you are filing without an attorney, you are responsible for an inventory with zero margin for error. If you miscalculate the value or find a hidden account later, the court will likely reject the petition. This forces you to start over with a formal, expensive administration. Precise math is the gatekeeper for this process. If the initial inventory is wrong, the shortcut ends before it begins. If the math works, the focus shifts to the court filing itself. You are required to draft several documents, including the petition for summary administration, the proposed orders for the judge, and the formal notices to creditors. Many people use a pre-formatted legal document template to avoid the cost of an attorney drafting these from scratch. The second row of our matrix reveals the next trade-off. Using a template is inexpensive, but you are acting as your own legal clerk. This means you are responsible for notarizations, filing fees, and delivering the paperwork to the circuit court. There is also the possibility of a court hearing. Without an attorney, you may have to speak before a judge to answer questions about the estate's debts and beneficiaries. Bypassing the typical $3,000 in legal fees means assuming the full administrative workload of the court system. The final consideration is debt management. In the petition, you must state that the estate is debt-free or that all known creditors have been handled. The benefit of this process is speed. Assets are often distributed in 8 to 12 weeks because you bypass the long creditor personal liability for any of the decedent's debts that appear later. This liability window remains open for 2 years after the date of death. For example, if a valid medical bill surfaces 18 months later, the creditor can personally sue the beneficiary for the amount, up to the value of the property inherited. Distributing assets quickly comes at the cost of this lingering financial risk for the heirs. Successfully settling a small estate yourself requires trading attorney fees for your own time and a 2-year window of risk. To decide which path to take, you can group your situation into one of 3 categories. Category with complex issues require formal probate. Category 2, qualifying estates with title disputes or hostile creditors need an attorney. Category 3, simple, debt-free estates with agreeable heirs are ideal for the DIY route. Placing your situation into one of these categories helps you avoid filing errors and protects the value of the inheritance. If your situation fits that third category, you can likely handle the process without professional help. For a simple, debt-free estate, paying several $1,000s for form preparation may not be the best use of the inheritance. The Chapter 735 Summary Administration Packet provides the tools for this strategy, including editable Word documents and instructions to file with the court. You can download the packet through the link in the description for $19.95. This allows you to settle the estate on your own terms.